Good day to you and welcome to another Paddocks Club video tutorial. Today I want to ask the question, on what basis must an owner pay for an exclusive use right? Now, owners and trustees in sectional title schemes regularly inquire whether the body corporate can charge money for the grant of exclusive use rights over a specified part of the common property. Typically, the common property involved will be parking bays, garden areas, courtyards, patios or balconies. Sometimes it will be the roof space above an original ceiling or a basement or an open space below the owner's section. The question of payment doesn't, of course, always arise, particularly when all owners are being given roughly the same rights at the same time. But when just one or a few owners are getting exclusive use rights, it isn't at all unusual for the body corporate to ask for the payment of money from the owner who's getting those rights. We start off from the position that the common property is owned in undivided shares by all owners of sections. So unlike in the case of a section extension, the owners are not losing their ownership, but they are giving up their rights to use that part of their shared property. Perhaps they would never have used the area in question anyway, but it's not unreasonable that they should want to be compensated, particularly if the area could potentially be rented out or turned to account in some other way. The Act doesn't deal with this aspect at all, but after the scheme is established, exclusive use rights can only be created by way of an owner resolution. Owners can and often do take the view that they won't agree to the necessary resolution and effectively give up their rights unless they're compensated, directly or indirectly. So if owners will only vote for the required resolution if the owners who are going to get the rights agree to pay, that agreement is the basis for their claim for payment. There are a number of issues that arise in any such arrangement. Does the compensation go to the body corporate to subsidize its cost, or is it to be paid to owners, either directly or via the body corporate? If so, what basis will be used to pay it out? If the price will be paid out by the body corporate, the trustees should also make sure that there'll be no income tax in the body corporate's hands, or if there will be, then that this has been taken account of. And if the payment is to be paid out under the prescribed management rules, then it's going to have to be a capital amount. And for that you get an opinion from your auditor. Is the payout to be on a pro rata basis or on the basis of participation quotas? Does the owner getting the rights participate in the payout? All this should be made clear. If more than one owner is to enjoy the benefit of the exclusive use area, how are they obliged to contribute to the costs? Again, this could be pro rata, it could be per their respective participation quotas, or it could be any other way they agree. But again, it should be made clear. How do you establish a fair price? I'll normally suggest that the body corporate obtain advice from an estate agent or a registered valuer to determine the market value of the rights. But it must be remembered that this is not an open market, because only the unit owners can hold exclusive use rights. So it's not the general public that must be considered, but only those owners in establishing the market price. Our recommendation is once that a price has been settled and the details have been negotiated, there should be a contract between the body corporate and the owners concerned, setting out the arrangements in detail and annexing the draft resolutions that are required to give effect to it. If you have any questions in this regard, let's deal with them in the discussion forum.